Good evening, everyone. My name's Tony Aspinall, and I'm the Regional Service Manager for the South West region. And we're delighted to be hosting this third webinar in the series of sessions on internationally educated nurses in the independent sector. Tonight's subject will be on understanding statutory pay in the independent sector, and I'll pass on to my colleague Barry a little later, and I'll introduce Barry. First of all, I just wanted to say a couple of housekeeping notes, really. We are happy to take questions, so the questions, if you wouldn't mind just posting in the chat, there will be time towards the end of today's webinar for you to have that question covered, and I'll make those for you. So any questions, just add them to the chat and we'll pick them up a bit later. In the chat also, you will see towards the end of the meeting this evening a link to feedback. It'd be really great if you could take some time just to give us some feedback how this webinar was and how it worked for you. And once we've got your feedback, you will automatically be sent a certificate of attendance for attending this webinar this evening. And without further ado, I'm going to hand over to Barry Hutchinson, who is our National Officer for Employment Relations, to run through some information which I'm sure you'll find very helpful. Again, just a gentle reminder, any questions, please just post in the chat. I'll hand over to my colleague, Barry.
Thanks, Tony. Good evening, everyone. As Tony said, I'm a National Officer with the RCN's Employment Relations Department. My background, I'm a registered nurse in mental health, and I'm also an employment solicitor. So this evening, our webinar is a follow-on to the webinar we did on the 17th of August when we looked at the different types of statutory leave. Tonight we're going to be looking at the statutory pay that is associated with those different types of statutory leave. We'll be talking about the difference between statutory pay and contractual pay briefly at the beginning of the webinar. Going to be then looking at the different types of statutory pay and how much the pay is, and we'll explain how you qualify for those different types of statutory pay. Next slide, please. So to start with, looking at the difference between statutory pay and contractual pay. Quite simple, really. The statutory pay is pay that the law says you are entitled to when you take certain types of statutory leave. Those types of statutory leave, as I said, we looked at our webinar on the 17th of August. Contractual pay is the pay that you agree with your employer and which forms part of your terms of employment. Now, contractual pay for the different types of statutory leave is possible. Your employer under your contract of employment can pay you more than the amount that the law says you must be paid, but what your employer cannot do is pay you less than the amount that the law says you must be paid. Some employers in the independent sector do actually pay more than the law says. Unfortunately, a lot of employers only pay the minimum legal amount. Next slide, please. This is the different types of statutory pay that we'll be talking through. Those of you who attended the webinar on the 17th of August and who have very good memories may remember that the list of different types of statutory leave was a little bit longer than the list of different pays that we have in front of us now. And that's because individual parental leave and dependence leave, you do not get paid for those two types of leave. The law does not give you the right to be paid for independent parental leave or dependence leave. Your employer could pay you for those two types of leave, but there is no statutory pay for those two types of leave. So the first pay that we're going to be looking at is statutory maternity pay. So next slide, please. So just briefly before we start on maternity pay, the issue about receiving any of the statutory pay, you must qualify for the statutory leave before you can get the pay, and you must take the statutory leave. Now, that might sound a little bit obvious, but I have in the past had members ask about whether they can take the pay and not have the leave. Well, no, you can't. And likewise, if you don't qualify for the statutory leave, then you will never qualify for the pay. So the qualifying criteria that I will talk about for each of the different types of pay, they are all based on you qualifying for the leave in the first instance. And with all of the types of statutory pay, in the same way as you would pay on your monthly or weekly salary, you have to pay income tax and national insurance on statutory pay. So the figures that I'll be talking about this evening are the gross figures. That means that they are the figures before you have income tax and national insurance deducted. Next slide, please. So, as I said, the first pay we're going to be looking at is statutory maternity pay. And again, those of you that were with us on the 17th of August may remember that you are entitled to up to 52 weeks of maternity leave, but you are only entitled to statutory pay for 39 weeks of that 52 weeks leave. The first 6 weeks of your maternity leave will be paid at 90% of your average weekly earnings. And what your employer needs to do is look at what your earnings were in the 8-week period before you start to take your statutory maternity pay and work out what your average weekly wage was. The remaining 33 weeks are paid at the statutory rate of £172.48 per week, or 90% of your average weekly wage if the 90% average weekly wage is less. So it's the lesser of the two amounts. The first 6 weeks, you will get whatever your average weekly wage is. The next 33 weeks, it is either £172.48 or 90% of your average weekly earnings, whichever is the lower of the amount. Next slide, please. Now, to qualify for statutory maternity pay, you must have been continuously employed by your employer for at least 26 weeks by the last day of the 15th week before the expected week of childbirth. So what you would need to do is have in mind the date that your child is due to be born. You would work back 15 weeks from that date, and at the end of that 15th week, you need to have had at least 26 weeks with your employer. Now that's 26 weeks continuous employment with your employer that you would be taking the leave and the pay with. If your employer doesn't include previous employment with another employer, then that won't count in your continuous employment for the purposes of your statutory maternity pay. You also need to give your employer at least 28 days notice of when you want your statutory maternity pay to start. You also need to provide your employer with proof that you are pregnant. Now that's normally in the form of what's called a MAT B1 certificate, and that simply stands for Maternity Benefit Number 1 certificate. Alternatively, you can have a letter of confirmation of pregnancy from your GP or your midwife, something like that. You also need to earn at least an average of £123 per week in that 8-week period up to the 15th week before the expected week of childbirth. Now, if you don't meet those qualifying criteria that are listed there, those 4 qualifying criteria, then you might qualify for maternity allowance. The difference between statutory maternity pay and maternity allowance is that the statutory maternity pay is paid to you by your employer, and it's paid from your employer. It comes out of your employer's budget, your employer's profits, whatever. Maternity allowance is paid by the government, and it comes from government's funds, from public funds. You will also still qualify and receive your statutory maternity pay if your baby is stillborn, but only if the baby is stillborn after the start of your 24th week of pregnancy. If the baby was stillborn before the 24th week of pregnancy, then you wouldn't qualify for maternity pay. And you would also qualify if your baby should die after birth. You would then still be entitled to the remainder of the 39 weeks of the pay that you were entitled to. Next slide, please. Statutory adoption pay. Like maternity pay, statutory adoption pay is paid for 39 weeks of adoption leave. Even though the total amount of adoption leave is 52 weeks, you only get paid statutory pay for 39 weeks. And again, like maternity pay, the first 6 weeks, it's 90% of your average weekly earnings. And that's everything that you would earn in a week. So it's not just your basic pay. It would include any enhancements for unsocial hours, any bonuses, things like that. The next 33 weeks, again, are paid like maternity pay at the rate of £172.48, or 90% of your average weekly earnings, whichever is the lower. Now, like maternity pay, and like all of the rates that we'll be going through later on with the different types of pay, the rate of the statutory maternity pay, that £172.48, is set by the government. It's reviewed annually, but isn't necessarily increased annually. The government can, and have in the past, choose not to increase it in a particular year. These figures that I'm giving you tonight with regards to the statutory rates are the figures that are correct today. If you are due to take adoption leave or maternity leave or some other form of leave in a few months' time, I would suggest that you check the government website, so that's gov.uk, because the correct rates will always be on the government website. These rates are correct as of today. I can't guarantee that there will be these rates tomorrow. It's highly unlikely that they're going to change tomorrow or next week, but in theory, the government could change them tomorrow. So just bear that in mind. Next slide, please. So to qualify for statutory adoption pay, again, you must have been continuously employed by your current employer for at least 26 weeks. And that 26 weeks is counted up to the last day of the week in which you are matched with a child, if it is a UK adoption, or the last day of the week in which the child arrives in the United Kingdom if you're adopting from abroad. You also need to give your employer 28 days notice of when you want your adoption pay to start, and you must give your employer proof of adoption. Now that could be the court order, it could be confirmation from the adoption agency that you've been matched with the child, but it needs to be some form of official notification for your employer. And again, you have to earn at least an average of £123 in the 8-week period up to you being matched, the week in which you're matched with a child or the child arrives in the UK. Now, unlike maternity pay, if you don't qualify for statutory adoption pay, there is not the equivalent of the maternity allowance. So there is no adoption allowance that you might be able to qualify for in the same way that you might be able to qualify for maternity allowance if you don't qualify for adoption pay. It is either, unfortunately, it's either adoption pay or nothing if you don't qualify for it. And you will not qualify for statutory adoption pay if you adopt a stepchild or a family member, or you adopt privately, for example, without the permission from UK courts or UK adoption agency. In those circumstances, they are not qualifying adoptions for statutory adoption pay, much the same as they would stop you qualifying for adoption leave. Next slide, please. So, statutory paternity pay. Again, if you were at the webinar on the 17th of August, you remember that you're entitled to 1 or 2 weeks of paternity leave. You either take 1 or 2 weeks of leave, and you will then get paid for 1 or 2 weeks of that leave. What you can't do is only take 1 week's leave and then try and claim 2 weeks paternity pay. You have to take the leave to get the pay. So if you wanted 2 weeks statutory paternity pay, you would have to take 2 weeks paternity leave. The rate again is £172.48 per week, or 90% of your average weekly earnings, whichever is the lower. And again, you will not be entitled to statutory paternity pay if you have received statutory adoption pay for the same child. You can't get 2 lots of statutory pay for the same child in an adoption situation. Next slide, please. Now, to qualify for SPP in a birth situation, you must have been continuously employed by your employer for at least 26 weeks. And again, that's by the last day of the 15th week before the expected week of childbirth. That's a bit of a mouthful. So again, as I said, for maternity, if you take the expected date of the child's birth, count 15 weeks back, then by the end of that 15 weeks, you need to have 26 weeks continuous employment. You must request paternity pay, and I've just noticed a typing error. That says SSP, that should say SPP. My apologies, that's one of the typing errors that slipped through. So to request SPP, you've got to give your employer at least 15 weeks notice before the expected week of the childbirth. And again, you need to earn an average of £123 per week in that 8-week period. And like the maternity pay, you would still qualify if the baby was stillborn after the start of the 24th week of pregnancy, or if the baby died after birth. Next question, please. Sorry, next slide, please. Now, with regards to SPP following adoption, the rules are slightly different if you are adopting within the UK as opposed to adopting from abroad. So if you are adopting within the UK, you must have been employed for the 26 weeks continuous employment, and that is counted as at the last day of the week in which you would be matched with the child. You also need to confirm to your employer that your partner is receiving statutory adoption pay, and you need to give your employer 28 days notice of when you want your statutory paternity pay to start. You need to also provide your employer with proof of adoption, and again, that can be the matching certificate or a court order or a formal letter from an adoption agency or UK authority. And finally, you need to earn at least £123 per week in the 8-week period up to being matched with the child. Next slide, please. Now, with regards to adoptions from overseas, from a child from overseas, again, you've got to have been employed by your employer for the 26 weeks continuous employment. And that 26 weeks is counted as at the date that the child arrives in the UK, or the date that you are wanting your statutory pay to start. You need to confirm to your employer that your partner is receiving statutory adoption pay, and you need to give your employer at least 28 days notice of when you want your SPP to start. You need to provide your employer with proof of adoption, as I said before, the adoption certificate, court order, a formal letter from an authority, and you've got to have earned at least £123 per week in that 8-week period up to the date that the child arrives in the United Kingdom. Next slide, please. Next pay we're talking about is shared parental pay. Now, this is, if you remember, if you were at this webinar on the 17th of August, shared parental leave is when partners share maternity leave or adoption leave between them. So shared parental pay is paid for up to 39 weeks of shared parental leave, minus any weeks that the mother has taken statutory maternity pay or the child's adopter has taken statutory adoption pay. So taking a birth scenario as an example, if the child's mother has 6 weeks maternity leave and takes 6 weeks statutory maternity pay, then the shared parental pay would only be available for 33 weeks. If the mother took 20 weeks leave with 20 weeks maternity pay, then you would only have 19 weeks of pay available to share. You have to deduct what the mother or the adopter has already taken. It's £172 or 48 pence per week, or again the 90% of your average weekly earnings, whichever is the lower. Next slide, please. So to qualify for the shared parental pay, you must qualify for statutory maternity pay or statutory adoption pay, or you must qualify for either statutory paternity pay and your partner qualify for statutory maternity pay, maternity allowance, or statutory adoption pay. Now, in addition to those qualifying criteria, you or your partner can't be receiving statutory maternity pay, statutory adoption pay, or statutory paternity pay, because if you remember, I said earlier, you can't get 2 different types of statutory pay at the same time. And you need to give your employer 8 weeks notice of taking shared parental pay. Now, there is also a long list of information that you must provide to your employer when you are giving them the 8 weeks notice that you want to take the statutory pay. I have not included that information in the slides or in the webinar because it's extremely complicated. So what I would advise is that anybody, excuse me, anybody who is thinking about taking shared parental leave or shared parental pay to go with that shared parental leave, that you contact RCN Direct if you are an RCN member to get proper full advice from our benefits team. If you're not an RCN member, well, you might want to think about joining the RCN, or you could go to somewhere like Citizens Advice Bureau, and they will be able to give you the full advice. It's very technical, because it's things like you need to provide proof of your partner being qualified for maternity leave and maternity pay. You need to provide proof from your partner's employer about the amount of maternity pay or adoption pay that they've already received. So it's quite complicated. So you need to take specialist advice if you're thinking about shared parental pay. Next slide, please. Then looking here at shared parental, statutory parental bereavement pay, and this is paid if you take leave following the death of a child. You're entitled to 1 or 2 weeks of leave, and again, like the paternity leave, if you only take 1 week's leave, then you will only get 1 week's pay. You can't have 2 weeks pay unless you take 2 weeks of leave. And again, the statutory rate at the moment is £172.48 per week, or 90% of your average weekly earnings. Next slide, please. So to qualify for statutory parental bereavement pay, again, you have to have been continuously employed by your employer for at least 26 weeks at the end of the week immediately before the week in which the child died or there was a stillbirth. You need to have earned at least an average of £123 per week in that 8-week period, and at least 28 days before you want to take the statutory pay, you've got to tell your employer that you qualify for the pay. You've got to tell your employer the periods that you want to take the pay. So does that mean you want to take it for 1 week or 2 weeks? And you've got to give your employer the date of the child's death, or if the child is stillborn, the date of the stillbirth. Next slide, please. Holiday pay. Now, this is a little bit complicated when we come to talk about a week's pay, so I'll try and explain this carefully. The statutory holiday is 5.6 weeks. Now, under the working time regulations, statutory leave is 4 weeks plus an additional 1.6 weeks. With regards to leave, it is just simply 5.6 weeks. Or you can have leave in days up to a maximum of 28 days. But when it comes to statutory holiday pay, the first 4 weeks of your statutory holidays are paid at your normal weekly pay. And normal weekly pay is the pay that you would have been paid if you had been at work. And I'll come on to what normal pay would be. The additional 1.6 weeks are paid at your basic rate. So that's your rate of pay excluding any enhancements, for example, that you might get for working on social hours. If you were taking your leave in days, then the first 20 days are paid at your normal pay, and the additional 8 days are paid at basic pay. Next slide, please. So, and this is where it becomes a little bit complicated. A normal week's pay for the first 4 weeks of your statutory leave. A normal week's pay has to include things that are set out on the slide there. So it has to include your basic pay, and your basic pay will be specified in your contract as an amount per week or per month or per year. If it's specified as an annual amount, then you would divide that by 52 to give you your basic weekly wage. If it's specified as a monthly amount, then you would multiply that monthly amount by 12 and then divide that by 52 to give you your basic weekly pay. Normal week's pay also has to include things like allowances or payments linked to the performance of your job. So, as I mentioned earlier, shift allowances for unsocial hours. If you get an enhanced rate of pay for working on a Saturday or a Sunday or a bank holiday, then those allowances, those enhanced payments have to be included. If you have some sort of productivity bonus or you have commission payments, they must be included in a normal week's pay. If you work contractual overtime, then that is included in a basic week's pay for holiday pay. Contractual overtime is the overtime which your employer has to offer you and which you must work as a contractual term. So, for example, your employment contract says you work 37.5 hours per week, Monday to Friday. That's your basic working week. And then the contract also says, but you must also work 4 hours every second Saturday, for example. Well, that's your contract saying you must work it. You have to work it. So that extra time has to be included in your holiday pay calculation. Likewise, non-guaranteed compulsory overtime, that's overtime which is not specified in your contract, which your employer doesn't have to offer you, but if your employer says, I want you to work extra hours on Saturday and you must work it, then that kind of pay, that overtime is included. And the final amount is voluntary overtime. And that's overtime which your employer might offer you, but you have the choice to refuse to work it. Next slide, please. So to calculate the week's pay, including all of those things that I've just mentioned, it's based on an average pay for a 52-week reference period. So what you would do is, starting with the first day of annual leave, you would work back 52 weeks and you would add up all of those payments that you received in that 52-week period, then divide it by 52, and that gives you your average weekly wage. And that's what you would do for those first 4 weeks. The extra 1.6 weeks, it's simply your basic pay that's specified in your contract or your pay slip. If you've been employed less than 52 weeks, then that reference period for working out your average is simply the number of weeks that you've been employed by your employer. If in the 52-week period there's a week that you've not worked and not been paid, so you may have took some unpaid leave, for example, then you need to go back further than 52 weeks to give you a full 52-week reference period. So if there was, I don't know, you had 2 weeks unpaid leave, what you would do is you would work back 54 weeks from the first day that you took your leave to give you 52 weeks worth of pay. However, the reference period, though, is limited to a maximum of 104 weeks. 2 years. And what that means is that if you've had lots of weeks in which you've not been paid, then you can't work backwards more than 104 weeks. So in theory, you could have an average weekly wage based on less than 52 weeks if you'd had 60 weeks unpaid leave, for example. Now, I say in theory because it's highly unlikely that somebody's going to have all of that unpaid leave in a 2-year period, but this is what the law says in relation to statutory pay. And if you remember, I said just before, one of the things that's included is voluntary overtime. However, the law does say for voluntary overtime to be included in calculating your average weekly wage, you have to work the voluntary overtime regularly. This element of pay came about following a Court of Appeal decision in 2019. Unfortunately, which is usually what happens in court cases, the Court of Appeal refused to define what regularly means. So if you're working voluntary overtime regularly and you want that included in the calculation of your holiday pay, then you and your employer are going to have to sit down and try and reach an agreement about what regular means. In the NHS, regularly means that you have to have worked the overtime in 6 months out of 12. But that's just for the NHS, for those people who are on NHS terms and conditions. In the independent sector, regular can mean whatever you and your employer agree. So it could be 1 week out of 52. It could be 2 weeks. It could be 3 months. It is whatever you and your employer can agree. Ultimately, if you and your employer can't agree what regularly means, then again, if you're an RCN member, you need to contact RCN Direct to be referred on to one of our regions or one of our countries for support from a rep or a regional officer. If you are not an RCN member, then you need to join the RCN, because it's not something that I would suggest anybody try and resolve on their own. Because ultimately, if your employer won't agree, then you'd be looking at an employment tribunal claim, and that's not something that anybody should contemplate doing on their own. Next slide, please. And the last type of statutory pay we're looking at is statutory sick pay. Now, statutory sick pay is paid from the 4th calendar day of absence due to ill health, and it's paid for a maximum of 28 weeks. So you don't qualify for statutory sick pay for the first 3 days of your sickness absence. You only qualify from 4th day, and it is calendar days, not working days. So if, for example, you were due to be at work Monday, Tuesday, Wednesday, and then you were off, and the following week you'd be at work Tuesday, Wednesday, Thursday, it's not the Monday, Tuesday, Wednesday and the following Tuesday that would count, because it's not 4 working days. It would be Monday, Tuesday, Wednesday that you would have been at work, plus the Thursday, which would be your first day off that you would have been sick. So what you need to do, a bit of advice, if you are going off sick, even if you are off sick, even if you are ill on a day off, you should notify your employer on the first day that you become sick. Because if you were at work Monday, Tuesday, Wednesday, and then we're on a day off on the Thursday and Friday, what you must not do, if you're going to be ill long term, if you think you're going to be ill for a couple of weeks, you must not ring your employer on the Thursday and say, I'm not very well, but I'm on my days off now. Because if you do that, your employer will stop counting you as sick leave. They will put you down on days off, and you will have only had 3 days off sick, so you won't get the sick pay. So you continue on the sick, even though it's your days off, so that once you get to the 4th calendar day, you then qualify for sick pay, and then you would get your sick pay up to 28 weeks. Likewise, what you can also do, if you wanted to, is after you've been at work Monday, Tuesday, Wednesday, if you became ill, say on the Thursday or Friday, you could phone in sick on your days off if you wanted to. And then you would have 3 days that you didn't get the sick pay for, continue from day 4. The rate of pay is £109.40 per week. You'll remember I said earlier about an amount and 90% of weekly average earnings. There is no weekly 90% of average earnings for statutory sick pay. It is simply a flat rate of £109.40 per week. Now, statutory sick pay can be paid at a daily rate. If you're only off for a number of days, if you're off sick for 4, 5 or 6 days rather than the full week. Qualifying days are the number of days that you're contracted to work each week. So, and this is where this gets a little bit complicated. If you were only contracted to work Monday, Tuesday and Wednesday, but you were off sick for a full week, so you're off sick for 6 days, you would not divide the £109.40 by the 6 days that you were off sick, because 3 of those would have been your days off. You wouldn't have been contracted to work. You would only divide £109.40 by 3 to give you the daily rate. If you were contracted to work 4 days, then you would divide the 109 by 4. If it was 5 days, you would divide 109 by 5. And that would then give you the daily rate for any period of sickness from day 4 up to day 7, because once you've then been off sick for 7 days, you're then into a full week, so you would then get that weekly rate. The other thing that you need to be aware of is that if there is less than 56 days between 2 periods of absence, then those 2 periods of absence will count as 1 period for the purposes of the 28 weeks for sick pay. So if you were off, say, 14 weeks, and then you went back to work, and you were back at work for, say, 3 or 4 weeks, and then you went off sick again, that second time that you went off sick, you would not be entitled to 28 weeks sick pay because you'd already had 14 weeks less than 56 days earlier. So on that second absence, you would only have 14 weeks of statutory sick pay left. If, however, you were off sick for 14 weeks and then you were at work for 60 days and you went off sick again, then that second time you went off sick, you would then be entitled to the full 28 weeks again. So it's that 56-day gap between 2 sickness periods you need to be aware of, because you might not qualify for the full 28 weeks on the second absence if it's less than 56 days between the 2 periods. Next slide, please. So to qualify for statutory sick pay, you need to have earned at least £123 per week in the 8-week period before you're absent. You need to be absent for work, as I said, you need to be absent for at least 4 calendar days. You need to give your employer proof that you're ill. So in the first 7 days, you would self-certify. Now that might be a phone call, it might be an email, it might be a text, whatever you and your employer decide. And then from day 8, you would need to give your employer a fit note, which you can get from your GP. Do all of that, then you would qualify for your statutory sick pay. Next slide, please. And this last slide here is just some contact information for RCN Direct or the RCN website for advice guides. Key number there for ACAS. The gov.uk is a government website that you need to be aware of for checking on the rates, and there's some Citizens Advice Bureau contact details there as well. That's all I have to say this evening on statutory pay. So thanks for listening, and I'll pass back over to Tony now. Thank you.
Thanks very much, Barry. Quite a lot of information there. It's quite a lot to take in. So we'll just leave that slide up for a minute for anyone to take some numbers or email addresses from. I did publish there. We've not received any questions, so Barry, you must have been really thorough. But I'm sure given some time, we'll get some questions through. Anyway, yeah, if we can take the next slide, please, Will. I'm going to briefly talk to you about reasons for joining the RCN. I'd like to think everyone on the call this evening is a member of the RCN, so you can take it back to share this information with your colleagues, because we know majority of our members join for the workplace support, but obviously there's a lot more that we can offer you as a member of the RCN. So again, please take this back to colleagues if they're not members, and if you're not a member yourself, hopefully some of this information will be useful for you too. One of our main areas is actually your professional development. So as a professional body, we do support lifelong development, and we have access to Europe's largest nursing library. We do have that available online, as well as we can email information to you, and we can send books to you if you're not able to get to your local library and you do need a nursing book. If you're close to London, or if you're ever visiting London, you're more than welcome to go to our head office, which is at Cavendish Square in London, which just behind John Lewis's. So you can go in there, go into the library, and you can see the amazing amount of information there. And if it's during the week, you can be able to talk to one of our librarians who can give you advice as well. Yes, we can show you workplace support. Really, really important. As Barry mentioned earlier on some topics, you really do need that backup to support you should you need that. And we are the only nursing specific trade union in the UK, and we can provide you with specialist workplace support and guidance. We do have a helpline, or RCND, which is RCN Direct, to take any concerns, queries, worries, or just generally information. If you need information, they can put you through to the right people. As an RCN member, you receive comprehensive legal advice. We have an in-house legal team, which is one of the largest in the UK of any trade union. And the day you join, you can get that support from our legal team. Some other unions make you wait for a period of time before you can get that legal support. With the RCN, the day that you become a member is the day you can get that legal support. And one thing I will say, if any of you come across times when you've had to get legal support, it is very, very expensive. So this is all free of charge to you as a member. Alongside this, we can offer you emotional and practical support. We can offer you immigration advice, welfare guidance. If you're having some financial concerns and you need some financial well-being, we can offer that guidance for you. We can offer you career coaching. We can assist with CV writing and preparing for interviews and career planning. We also have telephone counselling. We have a very extensive counselling department, provide support directly for our RCN members. And often we have peer support for members with disabilities. We have a very good disability forum too. And finally, they put their handy guide to common English expressions. Again, we've come across times where people are not too clear on some of the expressions that we use, and it gives you some clear guidance and explains what that's going on. And finally on that, we've got careers advice. You've obviously, where you are now, you may be happy, but you might be looking for that next step forward. By accessing the resources on the RCN website, we can give you advice. You can look at where your next steps can be. We can work alongside you on the website to look at development plans for yourself and where you want to go. Out there at the moment, we have over 500,000 members. So and they're all in the nursing family. So that can be either nurses, nursing assistants, and nursing students. So hopefully you've gained some information there, which you may not have known about the RCN previously. And so hopefully that clarifies that. Meantime, we do have a question, and I will publish it now for you to see. Barry, that's fine. Well, we can clear that slide now, please. Yeah, Barry, I have a question. Can I travel abroad and stay over 3 months as I earn maternity statutory pay?
Right, let me just check. So somebody, they're going on maternity leave, they're taking statutory maternity pay, and they're going to be out of the country for more than 3 months. Being out of the country for more than 3 months would not stop them being entitled to the statutory maternity pay. You are not restricted in where you can or cannot go when you are on maternity leave. So if I don't know, if somebody came from Italy and worked in this country and had their baby and were going to spend 3 or 4 months over the summer back with their family back in Italy, that you would still be entitled because you are on leave from work. You would still be known as what habitually resident in the UK for tax and national insurance purposes. You're not moving permanently abroad. You're going to stay with family for an extended holiday, for want of a better way of describing it. So yes, you would still be entitled to your statutory maternity pay. If you moved abroad permanently and were no longer employed by your employer, then that's a different matter. But if you're still employed by your employer and you are coming back to the UK after that extended stay abroad, then you'd be okay.
That's smashing. Thank you, Barry, and hope that's covered what's required. Just while we're waiting for any other questions to come in, Barry, is there any common themes that you've come across in your time doing this, doing the role, where there's been a common theme around holiday pay, sickness pay, or maternity pay that our members have had to have support for?
I think there's a couple of issues that do tend to crop up regularly, especially for internationally educated nurses, from nurses who've come from abroad who may be on a work visa. One of the questions that we do get asked quite often is, because it's statutory pay, because it's set in law, we quite often get asked if by getting that statutory pay, is that having recourse to public funds? And my understanding, I'm not an immigration lawyer, but my understanding is no, it is not classed as public funds. It is pay that is coming from your employer. The law may say how much it is, and the law may say that your employer has to pay it, but it's what you are getting paid when you are on leave in lieu of your normal wages from your employer. It's classed as your normal wages. The only one that might be considered as recourse to public funds is maternity allowance, because that is not paid from your employer, or the money doesn't come from your employer. They administer it, but it doesn't come from the employer. It's funded by government. It's a state benefit, not a pay. So if somebody was taking maternity leave and we're here on a work visa and didn't qualify for statutory maternity pay, but were looking to get maternity allowance, they would need to check first if they were entitled to have that maternity allowance if they can't have recourse to public funds. The other thing that crops up quite often is the arguments about how you calculate a week's pay for statutory holiday pay and what should be included in calculating an average weekly wage for those first 4 weeks. Not unsurprisingly, employers want to exclude as much as they can possibly exclude because it means they pay less, whereas employees want to include as much as they possibly can, quite rightly, because if it's what you would have earned if you'd been at work, then it should be included in your holiday pay. But quite often, employers will try to maintain that you're only entitled to your basic pay for the full 5.6 weeks, because that's the position for that additional 1.6 weeks. Employers try and I'll put it bluntly, some employers will basically lie to their employees and say, no, the law says you're only entitled to basic pay. Well, that's not true. You're only entitled to basic pay for 1.6 weeks. The first 4 weeks, you're entitled to full normal pay. So those are the two things that tend to crop up quite often. So be aware of the holiday pay business, because I'm sure some employers will try to pay you as little as they possibly can get away with.
That's great. Thank you, Barry. And my final one is really still checking there's any other questions coming in from anyone. No further questions. It's just around sickness, really, Barry. Obviously, some people are saying, you know, they go sick and they're worried for going sick because it may have implications on their employment, and especially if they're on a visa or anything. Is there any information that's worth sharing to ease anyone's concern over that?
Well, the fact that somebody may be here on a visa does not stop you being entitled to statutory sick pay. So that we need to be clear. If you are employed and you're off sick, you're entitled to statutory sick pay. If you've got the right to work in this country, then you're entitled to statutory sick pay when you're off sick. I think one of the things that obviously does concern some people is about how long they're off sick for, and whether their employer can dismiss them when they're off sick. And this did crop up on the webinar on the 17th of August. And what I said then is much the same as now, is that yes, an employer can dismiss somebody who's off sick, because if you're off sick, you're not able to work, but it would have to be long-term sick, and the employer would have to have conversations with them about looking for an alternative job to help the person back to work, or looking at adjusting the person's job to help them come back to work. They have to look at trying to make the job less stressful, make it easier, perhaps change what they do, where they work, all sorts of things that the employer would have to go through first. Because if they didn't do any of that, then it would be an unfair dismissal, and you would pursue that in the employment tribunal and would be entitled to compensation for that unfair dismissal. So employers are unwise to sack somebody who's off sick, because it's difficult for the employer to convince an employment judge that it would be a fair dismissal.
That's great. Thank you, Barry. We're coming towards the end now, so just wanted to thank everyone for attending this evening. Barry, special thanks. It's been so thorough, and I'm sure, sorry, right in front of me. I'm sure everyone's picked up so much information. As Barry said earlier, as an RCM member, if you're not sure, please just give RCND a call. Their number will publish it for you towards the end, but it's 0345 772 6100, and they can give you the information that you may require. Finally, I just want to head you into the direction of the chat again. As a reminder, for those of you that have joined this evening, thank you so much. There is a link there that will be available after the call ends. Please click on it, give us the feedback, what you found helpful, also anything that we might look for in the future that we can provide for you. And as my colleagues put there, we will send you a certificate of attendance. So just while we've got a couple of minutes, I'll just open up. If there is any questions, please pop in the chat for us now. And then we can just cover that. Doesn't look like it, Barry. You've been more than thorough, my friend. I'm just going to say thank you again, and just another reminder, please do the feedback. Please pass on to your colleagues that haven't been able to join us tonight. This video will be available on YouTube if anyone wants to catch up with it. I believe it's going live in the next couple of days, so please do that. And finally, please join the RCN for all the support that you need, whether it be educationally, your personal development, or at work, union support or advice. So we'll say thanks again, and have a very good evening, everyone.